Welcome to everyone who is joining us today. Just a quick word on the genesis of this program series. We do a lot of work for healthcare clients all across the country, and it's always amazing how unique the issues that healthcare employers face are. And we thought it would be helpful to walk through some HR topics that are common to most employers, but in a way that it's specifically impacting healthcare employers today. So, our first session, we're going to talk about handling requests for disability and religious accommodations. My information is here, and just so you all know, the PowerPoint, I believe, will be made available to everyone as well. Here's our agenda today. We have a lot to cover. What we're going to go through are disability and religious accommodation basics. We're going to talk about a Supreme Court decision from this past summer that has had an impact on employee religious accommodation requests and how we have to handle them as employers. And then we'll talk about lessons learned from the CMS and New York State healthcare vaccine mandates. I've had a lot of experience with litigating claims related to those mandates, so we'll talk about some things that we can glean and learn from those mandates as we move forward. All right, so without further ado, let's get right into some disability accommodation basics. The general rule, and I don't think I'm telling anyone anything they don't already know, but the general rule is that employers are required to provide reasonable accommodations to qualified individuals with disabilities who are employees or are applicants for employment, unless to do so would cause undue hardship. This is the general rule, and we'll walk through how this rule is implemented and how and what it requires you to do in just a minute. But I wanted to give you the quick overview, the general rule first. I will say and give a disclaimer at the outset of this presentation that any accommodation request, whether it be disability related or religious related, is going to be fact specific, and how you analyze and handle a request will depend on the specific facts and circumstances related to that request. What I'm going to try to give you are the general rules and keys to evaluating and handling one of those requests. So first of all, what are the different types of or categories of reasonable accommodations? According to the law, there are three. The first is modifications or adjustments to ensure equal opportunity to the application process. So this applies to individuals who are applying for a position. Examples could be someone in a wheelchair who may need an accommodation to access an inaccessible interview site. Another type or category of reasonable accommodation is modifications or adjustments to enable a qualified individual with a disability to perform the essential functions of their position. These are the accommodations that most of you are probably most familiar with when someone comes to you as an HR professional and says, I have this medical condition and I need an accommodation. The third category are modifications or adjustments to enable an employee with a disability to enjoy equal benefits and privileges of employment. This category encompasses things such as equal access to lunchrooms, restrooms, meeting rooms, etc., for all employees, including disabled employees. Examples of some specific reasonable accommodations include making or existing facilities accessible, including ramps, etc., things like that. Job restructuring, maybe you need to alter the duties of a particular individual with a disability as an accommodation. Part-time or modified work schedules, this includes potential leave as an accommodation. Acquiring or modifying specific equipment to allow an individual with a disability to perform the essential functions of their position. Changing tests, training materials, or policies, or providing qualified readers or interpreters. Reassignment to a vacant position. These are all examples of reasonable accommodations. I didn't include this list as a comprehensive list, more of just as a summary of some potential things that you can do to accommodate employees with disabilities. Importantly, what are some things, excuse me, that are not reasonable accommodations? The first one is something that I'm sure you all have heard is you as an employer are not required to eliminate an essential function of a position. So if there is an essential function of a job that an employee with a disability cannot perform, with or without an accommodation, you would not be required to provide that employee with an accommodation. Similarly, lowering of a production standard. You don't have to lower quantifiable or qualitative production standards for individuals with disabilities. You may, however, be required to provide an individual with a disability an accommodation that allows them to meet that production standard, but you don't have to reduce the production standard. Providing personal use items needed to accomplish daily activities on and off the job. So, for example, you don't need to provide an employee with glasses or a wheelchair, which are which are things that the employee would need both in their non-work life and in their work life. In addition, you would not have to excuse the violation of a uniformly applied rule to accommodate somebody with a disability. All right, now who is entitled to a reasonable accommodation? Well, the different laws provide different definitions. So under the Americans with Disabilities Act, which is the federal law prohibiting discrimination against individuals with disabilities, someone with a disability is entitled to a reasonable accommodation if he or she is a, quote, qualified individual with a disability. Under New York State, the New York State Human Rights Law, that definition is a little bit different. And I will say that the federal law and the state fewer conditions. All right, when is an employer obligated to provide a reasonable accommodation? And we're getting into the meat of the issues here. Well, the way that it typically works is that an employee or an applicant will notify the employer that an accommodation is needed. This typically either comes to the employee's supervisor or directly to HR. Notably, under the law, the request does not have to be in writing. It can be in plain English. It doesn't have to mention accommodation or the ADA or any specific law or the phrase reasonable accommodation. It can be made by a representative of the individual, including a family member, friend, or health professional. Once that request is made, an employer has the obligation to begin what we all know of as the interactive process. An employer can begin that process even if a request is not made by the employee under these specific circumstances. So if the employer knows the employee has a disability, knows or has reason to know the employee is experiencing problems because of the disability, and knows or has reason to know that the disability prevents the employee from asking for an accommodation, in those circumstances, an employer would have the obligation to begin that interactive process, even without a request. So what to do once the accommodation is requested? There are a number of things. First, we start with analyzing the job at issue. What's the job? And what is the job's purpose and essential functions? So if you are looking at, you get an accommodation request from a surgical tech, that's the analyzation of that particular job is going to be different than if you get a request for an accommodation from a receptionist. So the first step is look at what the job is, look at what the essential functions of that job are. You should also then consult with the disabled individual to understand the precise job-related limitations and how those limitations could be overcome with an accommodation. I typically recommend that clients utilize an accommodation request form in these circumstances because it will provide clear documentation of what the employee is asking for, what condition they say they have, what limitations they say they have. And that form will also typically have a section for documentation from a medical provider, which we'll talk about in just a second. So you consult with the individual with the disability. In consultation, after you've talked to the individual with the disability, you then can identify potential accommodations and assess how effective each accommodation would be to enable the individual to perform the essential functions. It's important to note here that you don't have to provide the employee's preferred accommodation. You have to provide an effective accommodation. So you have to provide something that addresses the issues that are raised by the employee's condition, not necessarily exactly what the employee wants. You can then request documentation concerning the nature and extent of the disability and the need for an accommodation. And here, I think that accommodation request form is helpful if it has a section for the medical provider to complete, because you can ask the specific questions that you want to ask rather than just asking for a doctor's note and getting something that's unhelpful. Importantly, a couple of important notes regarding documentation. An employer can't ask for documentation when, one, both the disability and need for accommodation are obvious, or two, the individual has already provided the employer with sufficient information. So if you think about one, if you have an employee who is deaf or blind, there wouldn't be any need to understand the disability. You may need to understand the need for accommodation or what specific accommodations are being requested. But in terms of the disability itself, you wouldn't need to understand that. Also, an employer can't ask for documentation that is unrelated to determining the existence of a disability or a need for an accommodation. So, for example, you wouldn't be able to ask for an employee's entire medical file because that wouldn't be relevant to the accommodation request or the condition that underlies the accommodation request. So those are two things to keep in mind. If an individual's disability or need for an accommodation because they would be cutting off the interactive process and not participating in it. So those are some steps to walk through. Now, I always, when I analyze reasonable accommodation in either the disability or religious context, I'm usually doing that in the context of litigation. So I am looking at it in hindsight. I think it's helpful for HR professionals to take the same view as the process is going on, because if you think about this accommodation request, whatever it may be, in terms of how am I going to defend this and what we as an employer did in litigation, I think it gets your frame of mind in the right place so that you can appropriately respond to the accommodation request. So here are some tips for how to demonstrate good faith during the interactive process. And this is looking back with hindsight. How do we defend against a claim that we didn't properly accommodate an employee? Well, you meet with the employee. That's always a good first step. You request information about the individual's condition and limitations. You identify what the employee is requesting specifically. You show some sign of having considered the employee's request. And you offer and discuss available alternatives when the request is too burdensome. All of these things should be documented. And that's an important point, is that documentation is the best evidence always of what you're doing in real time. And it's the best way for us to defend against a claim later on that we didn't engage in the appropriate interactive process or we didn't grant an appropriate accommodation. Here I say, I know we talked about it, but employers should consider utilizing an accommodation request form that includes all of these questions that you want to ask the individual and the healthcare provider at the same time. You're going to want to memorialize your conversations regarding the accommodation with your employee. That could take the form of a follow-up email to the employee that says, thank you so much for meeting with me. As we discussed, I just want to summarize what we talked about. You could then also write a memo to your file, the individual's file, that includes a summary of the steps that you took and how you went about considering the request for accommodation and responding to it. All right, switching gears just a little bit. If you go back to the original definition or general rule that we talked about first, an employer has an obligation to provide a reasonable accommodation to a qualified individual with a disability, unless to do so would constitute an undue hardship. So there's this big question, and it's really an important question from the legal perspective. What is an undue hardship? So an employer, the general rule is an employer doesn't have to make a reasonable accommodation if it imposes an undue hardship on the operation of its business. The various laws define undue hardship a little differently, but in general, with respect to disabilities, an undue hardship is one that requires significant difficulty or expense, one that is unduly costly, expensive, substantial, disruptive, or would fundamentally alter the nature of the operation of the business. As with many things that lawyers do, we use words that don't necessarily have the same meaning to everyone. So what is a significant difficulty or an expense? What are these things? What is unduly costly? I will tell you that there is no clear 100% answer to those questions, but we get some clues from cases where courts give us some information. We also get clues from guidance. So the Equal Employment Opportunity Commission, the EEOC, issues guidance that is helpful for employers in this specific arena. And it tells us a couple of factors that it considers when it's looking at whether there was an undue hardship. So first of all, the nature and cost of the accommodation, that is financial included, the overall financial resources of the facility making the accommodation, the number of persons employed at the facility, the effect on expenses and resources of the facility. And the use of the word facility is important there because a facility where someone works may be part of a larger institution, but if you can establish that the proposed accommodation would constitute an undue hardship on that particular facility, that can work. Another factor to be considered is the type of operation of the employer. Here, when we're talking about healthcare employers, you have an argument regarding the importance of the business that you provide and the urgency of any needed attendance or things like that. You can also look at the impact of the accommodation on the operation of the facility, including the impact on other employees. I will tell you that case law has told us the impact on other employees, if it's just angst or anger by other employees, that's not going to be enough. But that's one of the factors that is considered. I will also tell you that hypothetical costs aren't necessarily going to be enough. So if you were to say, well, we think that employees are going to be upset with this particular accommodation that we're going to give to another employee, that's not going to be enough in the eyes of a court. They require actual cost. So in some instances, you may have to let it play out before making this undue hardship analysis. Another thing to consider is how do you as the employer treat similarly situated non-disabled employees? So if a non-disabled employee came to you and asked for a particular accommodation, say I want to leave early, to pick up my kids or something that has nothing to do with a disability, and you granted that request of that employee, that could be relevant evidence when considering whether it would cause an undue hardship to grant the same accommodation to a disabled employee. So that's something always to be considered. Another thing that's particularly relevant for healthcare employers are the terms of a collective bargaining agreement. So I should note that employers can't claim undue hardship simply because a proposed accommodation violates the CBA, but that's certainly evidence. case law has told us that circumventing a collectively bargained seniority system would likely constitute an undue hardship. So that in and of itself may be enough to establish an undue hardship. All right, so let's talk about a hypothetical here in the healthcare context. We have Sue, a respiratory therapist in a hospital, and Sue is occasionally mandated to work overtime to cover staffing shortages. One day, Sue comes to HR and says that she has anxiety and her doctor is telling her that she can no longer work overtime. How should HR handle Sue's request? Now, at this point, I wish we were in person so that I could ask the audience this question and then you could provide some feedback and answers. But as I'm sitting here talking to the screen, I'm going to have to walk through the analysis myself, which I think is less enjoyable for everybody. But in any event, let's walk through this analysis. So Sue, in coming to HR, she has begun the interactive process, right? She has told us, I have a disability and I need an accommodation. So we start that interactive process. If you as an employer at this point utilize an reasonable accommodation request form, you could say, Sue, thanks so much. Here is our form. We ask that you fill out the front portion of it, which asks you questions about your disability and limitations and proposed accommodation. We'll also ask that you have your healthcare provider fill out the second page and tell us more about your condition, limitations, how it impacts your ability to perform the essential functions of your job, and what accommodations he or she is requesting. So that would be the first step, right? Once that information came back, you could have another conversation with Sue to figure out, well, first of all, you're going to look at the form to determine whether or not Sue has a quote unquote disability, as that term is defined by the applicable laws. If so, then you'd look at what accommodation she is specifically requesting. In this case, she's saying that she can't work overtime. Well, okay, how is working overtime limited by your specific condition? You would then identify some potential accommodations. Maybe not working overtime isn't the best accommodation to work with Sue's anxiety, and you can have a dialogue about that with her. You also are going to perform an undue hardship analysis here. So you're going to say, do I have staffing issues that might make this, that Sue's request might significantly impact the operation of my facility? Are there CBA seniority issues here? Is there a collective bargaining agreement that would disadvantage certain other employees in Sue's position? I would look at how have we treated other people who've made requests about overtime that are unrelated to disability. I would look at how this particular request is going to impact our operation. Is it going to impact other employees? And if so, how? It's going to be a very fact-specific analysis, but I'm going to walk through it all, and I'm going to reach a conclusion about whether or not we can grant the specific accommodation that Sue is requesting, or if we can, or if we can't. And if we can't, are there other accommodations that we can offer to Sue that would address the limitations she's identified? So all of this, you're going to go through all of this analysis. You're going to document the process, and hopefully you are going to come to an accommodation that, or come to an agreement with Sue about an accommodation that works and that is going to effectively address her disability. You're then going to write up a summary of everything that's happened and the conclusion, and make sure that it's clear that you are complying with the applicable laws. So that is the analysis of Sue, the respiratory therapist's accommodation request. All right, let's move on. We have a lot to cover here, so I apologize if I'm going quickly, but I want to cover a lot of material. All right, so that was disability accommodation requests. Now let's look at religious accommodation requests. The general rule as it applies to religious accommodation requests is quite similar to the rule addressing disability requests. The rule is that employers are required to reasonably accommodate an employee whose sincerely held religious belief, practice, or observance conflicts with a work requirement. unless providing the accommodation would create an undue hardship. So you see some similarities here, right? You see that you got to provide the accommodation unless there's an undue hardship. The basis for the accommodation, however, is different, right? It's a sincerely held religious belief that conflicts with an employment requirement. All right. So what is a sincerely held religious belief? And this is going to seem a little self-explanatory, but of course, lawyers make everything complicated. So first of all, it's a belief that's religious. And what is a religious belief? There has to be some basis for the belief embedded in the employee's religion. Doesn't have to be a traditional religion. And I will tell you that courts utilize a very broad definition of what constitutes religion, but it has to address ultimate ideas about life, purpose, and death. It can't be just a simple belief about freedom or anything that's not dealing with these ultimate ideas about life, purpose, and death. Importantly, and we saw this in the COVID context, it doesn't necessarily have to be a tenet of a particular religion, so long as the belief stems from something in the employee's religion. So we saw this a lot with COVID vaccines. Employers tried to take the position that because someone was Catholic, they couldn't have a religious objection to the vaccine because the Pope and other leaders had endorsed it. But that's not how this works. The belief doesn't have to be generally accepted by a particular religion to constitute a sincerely held religious belief. Here are some beliefs that are not religious. Social, political, economic views, not religious beliefs. Personal preferences, not religious beliefs. So if someone says, I'm exercising my God-given free will not to be vaccinated, that doesn't constitute a religious belief. Now, the belief not only has to be religious, but it has to be sincerely held. So we saw this a lot in the COVID context when employees would come and they would say, I have this belief I can't be vaccinated. And employer clients would come to me and say, well, we know that they receive other vaccinations. So, I'm questioning whether the belief is sincerely held. I will tell you that in the COVID context, the EEOC came out with new guidance for employers, which kind of helped with dealing with this actual specific issue. So typically, an employer is supposed to assume that a religious belief is sincerely held. However, the EEOC clarified that an employer could request additional documentation where there was an objective basis to question the sincerity of the belief, such as in these situations. So for example, where the accommodation sought was particularly desirable and likely to be sought for non-religious reasons. The COVID vaccine was the impetus for this particular factor, because a lot of employees were submitting accommodation requests on multiple bases. I have a disability, I can't get vaccinated, and I have a religious belief that can't get vaccinated. So that causes the employer to pause and to question the sincerity of the belief. Also, where the employees acted in a manner inconsistent with the professed belief. So I can't get vaccinated, but I got the flu vaccine, I've gotten all other vaccines. Why does my religious belief prevent me from getting this particular vaccine? Where the timing of the request renders it suspect. Again, I'll use the COVID example. An employee submits a request for a disability accommodation to not get vaccinated. You as the employer say, no, we're not granting your disability exemption request. A day later, they submit a religious exemption request. The timing of that makes it a little bit suspect. Also, where the employer otherwise has reason to believe the accommodation is not sought for religious reasons. So this is a catch-all where you as the employer could come up with other basis for questioning the sincerity of someone's belief. So you have an employee belief that is sincere, it's religious. So what are some of the common methods of religious accommodation? They're very similar to the accommodations that you see in the disability context, although how they're implemented is usually different. So you could have schedule changes, you could have voluntary substitutes and shift swaps. So you could say to an employee who's requesting an accommodation in the form of leave, okay, well, you can ask other employees if they can swap shifts with you so that you can be accommodated, or you could have them substitute their shift for yours. Those are some examples. You could change an employee's job tasks or provide a lateral transfer for certain employees who can't do certain tasks. An example of that would be, let's say you have a healthcare provider, a doctor, or a mid-level who has a religious objection to contraception. You could allow or have a process in place where other providers, anytime that provider was asked to write a prescription for contraception or Plan B or some other potentially problematic prescription, there could be a process where that employee or provider seeks out another provider who can fill in and do that. You could make an exception to dress and grooming rules. Again, to the extent they don't involve or would violate safety requirements. You could provide a space for the individual to engage in religious observance, whether that's prayer or some other religious observance. You could also accommodate prayer and other forms of religious expression. Now, the process for accommodating religious beliefs is very similar to considering a request for a disability accommodation. In this case, though, it has to start with the employee notifying you that they have a religious belief that contradicts with some employer requirement. So you have that request. What happens next? You have you as the employer engage in the dialogue regarding the belief and how it conflicts with your employment requirement. I would suggest using an accommodation request form similar to that which you use for disability accommodation. The only difference being there wouldn't be a section for their healthcare provider to fill out. You're going to want to consider possible accommodations. And then you're going to provide the accommodation that is effective, unless to do so would cause an undue hardship. Now, this is the Supreme Court case I wanted to talk through. What is an undue hardship in the religious accommodation context? From 1977 through June 29th of this year, undue hardship in the religious context was more than a, quote, de minimis cost. So there was a Supreme Court case in 1977 that said an employer faced with a religious accommodation request could deny that request and say that it caused an undue hardship so long as the burden was more than de minimis. So if you remember, we talked about in the disability context, it had to be significantly difficult. The request had to provide significant difficulty or expense. So that's a pretty high bar. For years, for almost 50 years, the bar in religious accommodation cases was much lower. So an employer could establish an undue hardship with much less significant hardship. That changed on June 29th of 2023 when the United States Supreme Court issued its Groff versus DeJoy decision. I'm going to talk to you a little bit about the facts that went into the Groff decision because I think they're relevant. So you had a Postal Service employee whose religious beliefs prevented him from working on Sundays. He asked for an accommodation that he not be allowed to work, and the Postal Service denied his accommodation request. They claimed that it would result in an undue hardship based upon the inconvenience to other employees and the disruption in the workflow. The employee brought a suit, filed a claim, said, "You, my employer, you're discriminating against me based upon Title VII, Civil Rights Act, 1964. The lower courts, following the established law since 1977, agreed with the Postal Service and said, yeah, this is undue hardship. The bar is very low. You only have to show it's more than a de minimis burden. And so we're gonna grant the Postal Service's motion to dismiss the case. The case went up the appellate level and to the United States Supreme Court. And in their decision on June 29th, they said, no longer can employers rely on this de minimis burden. That's not the right standard. What employers are now going to have to show is that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. Now, why they didn't just adopt the same standard that was applicable in disability cases, I don't know. But what we do know is they got rid of the de minimis burden and now have articulated this new standard. As courts like to do, they didn't really give any guidance about what this new standard was. For those of you in New York, this is going to sound a lot similar to what the state did with respect to sexual harassment claims. The burden for establishing sexual harassment used to be that the conduct needed to be severe and pervasive. New York passed a law that said, we're not going to follow the severe and pervasive standard. We're going to say something is sexual harassment if it constitutes more than petty slights or trivial inconveniences. Again, what does this mean? I don't know. The lawyers writing statutes that use words that don't have clear meanings is a tale as old as time. But that's the same thing as what we're dealing with here. So the court did give us some guidance. So we know that an impact on coworkers alone is not going to be sufficient. The impact has to be on the conduct of the business, and employers are going to be required to consider accommodations other than what is specifically requested by an individual. So we now know, based upon this Supreme Court case, that denying a religious accommodation request because it causes an undue hardship is going to be much harder than it was 6 months ago. We know from case law that before Groff, here are some examples of what constituted an undue hardship. Allowing an employee to use no social security number or a fake social security number. Violating a bona fide seniority provision in a CBA. I think that one's still going to remain. Making an exception to a dress code that would allow the employee to wear clothes inconsistent with safety requirements. Or allowing an employee to proselytize in a way that was harassing. So we know that before Groff was decided, these things all constituted an undue hardship. Whether they do now remains to be seen. But those are some examples of what was an undue hardship. Okay, so let's do a hypothetical involving a religious accommodation request. So we have John. He's a registered nurse at a hospital. He's required by his collective bargaining agreement to work every other weekend. One day, he comes to HR and he says he's a devout Christian and that his religion prevents him from working on Sundays. How should HR handle his request? Now, again, the process is going to be very similar. We're going to look at, is this a sincerely held religious belief? Do we have an objective basis for questioning the sincerity of John's belief? If so, we can request documentation. We also then look at this undue hardship analysis. Well, we got to look at the collective bargaining agreement if there's any seniority issues that are implicated. We have to look at staffing rules, whether or not him being absent on every single Sunday is going to impact whether we have adequate staffing. We have to look at Labor Law 167 and how its mandation rules might impact whether we could mandate other nurses to cover his shifts. If not, then that may tip the scale in favor of undue hardship. We have to look at operational issues. How is this going to impact the business of the floor on which John works and the hospital in general? There are a lot of factors that have to be considered here. We have to document our process, document our conversations with John, and document the outcome. All right, the last thing I wanted to do is to talk about the COVID-19 healthcare vaccine mandates that we saw and some lessons learned relating to those vaccine mandates as they relate to accommodations specifically. So we know, and everyone here, I'm sure, saw a flood of accommodation requests, both religious and medical, shortly after New York State and CMS put in their healthcare vaccine mandates. So we know that New York's vaccine mandate, which was recently repealed, required covered healthcare providers to ensure that their employees were fully vaccinated against COVID-19. The New York State mandate provided for limited medical exemptions, but it did not permit religious exemptions. And this was a problem for many employers in trying to understand what they were supposed to do with accommodation requests. The CMS vaccine mandate was similar, although it allowed for both religious and health medical exemptions. I will tell you that these are just some things that I have encountered in litigation in cases involving the healthcare vaccine mandate, and whether or not we as healthcare employers adequately accommodated our employees. The procedures for responding to these accommodation requests, I always like to see documentation of the request, medical support for the request, documentation of the process for reviewing the medical basis for the request. Now, I will say that as healthcare providers, you are in a unique situation in that you have physicians at your disposal who can evaluate medical accommodation requests. With respect to the vaccine, you had employees who were trying to say they were allergic to the vaccine, and you could have physicians on staff look at the medical documentation they submitted and say, no, there is no medical contraindication based upon what they provided to them being vaccinated, and you could deny the request on that basis. To the extent that you did that, though, you needed to have documentation of the process that was followed, who was reviewing the requests, what the decision was, and what the basis of the decision was. Also, what's helpful in these cases was if the request was denied or if the request was qualified, identifying potential accommodations, documenting the outcome of the request, and communicating to the employee. Same thing for religious accommodation requests, although these got a little more tricky because, as I mentioned just a moment ago, and all of you know, the New York State healthcare vaccine mandate did not allow for religious exemptions. The state didn't do healthcare employers any favors because it said that healthcare employers could provide accommodations to religious requests. However, those accommodations couldn't remove the employee or had to remove the employee from the definition of personnel in the regulation. So in other words, you as an employer could theoretically provide an accommodation to someone who was requesting a religious exemption from the vaccine, but you would have to have them take on a job where they wouldn't be in any way potentially exposing any other employee or patient. This was practically impossible in most circumstances. So for example, if you had a floor nurse in a hospital and that floor nurse requested an exemption from the vaccine mandate based upon his or her religious beliefs, the only option for an accommodation you would have is to take them out of their job as a floor nurse, which is arguably an essential position, a function of their position, one-on-one contact with patients. So the state set healthcare employers up for failure in this circumstance by providing this incredibly convoluted explanation or guidance of how to deal with religious exemption requests. Now, we saw some examples of accommodations, exemption from the request, masking, social distancing, modified shift, but masking, social distancing, and modifying a shift aren't going to satisfy the state's requirement that that individual be completely removed from any situation where he or she could potentially expose someone to COVID. We have seen many claims from employees against healthcare employers regarding improper denial of exemption and accommodation requests related to the vaccine and failure to adequately engage in the interactive process before denying the request. These claims were made both to the administrative agencies that handle discrimination claims, the EEOC and the Division of Human Rights. They've also been made in court. We've handled a number of these claims, and it's interesting to report that federal courts, so cases that were brought in the Southern District, Eastern District, and Northern District of New York, federal courts have consistently dismissed these claims out of hand. And the rationale is that granting an exemption to the vaccine requirement based upon someone's religious beliefs would necessarily cause the healthcare employer to violate a law, which was an undue hardship. So the federal courts have been very consistent, dismiss these claims, and they've been great. State courts, on the other hand, have taken a slightly different approach. If you, as the employer, don't have evidence that you engaged in the interactive process and evidence that you considered alternative accommodations, some state courts have said that's enough to keep a claim alive. Now, whether or not the plaintiffs would ultimately succeed in their state court claims, that's yet to be seen. But the state courts have taken a little different approach to these claims than the federal courts. Some lessons learned, and I think some lessons that are important to take away here. Number one, it's important to have a clear process for receiving and processing accommodation requests, both in the disability and religious context. It's important to have documentation of your process, communication, and consideration of the request and potential accommodations. It's also important to consider alternative accommodations, even when they're clearly unavailable. So, documenting that we thought about, are there other ways that we could accommodate this individual? And saying there weren't any. Having that in documentation is helpful. And documenting the outcome. Again, this is all from a litigator's perspective. These are things that I love to see when there's a claim that's filed, and I can go to you and I can say, all right, show me your documentation, your process, show me your documentation that you received from this individual, show me the proof you engaged in the interactive process and what that was, and then show me the documentation of the outcome. That's always the best place to be in. All right. That is it for me. I know I went a little bit over. I apologize. I see that there are some questions that I have not been able to get to. Be on the lookout for our next presentation in this series. It's as Kathy mentioned, it's December 14th. It's going to be me, and I'll have a special guest with me to talk about hiring and staffing issues in the healthcare context. I know that is a topic that is very important to all of you. It was great to be with you today, and I look forward to seeing you next month.